This is for the minutes of May 13th, June 3rd, and June 10th. I hope everyone had a chance to look them over. Any discussion?
Thank you, Jeffrey.
Yes, thank you, Jeffrey. All right, all in favor?
Aye.
All right. I'd entertain a motion to take items 2 and 3 as a package off the table for the purpose of inviting our speakers in and receiving the communications from our clerk and from the state rep, Pat Duffy.
Do you want to take 4?
What about 4?
We could. Do you want to take 4 off the table as well? 4 and 5 are, to be honest, very similar in nature.
True. Okay.
So if we're going to take anything as a package, I thought we could take 2 and 3 up just to receive and then take action on 4 and 5.
Okay.
Or we can take 2 through 5 up as a package. It's the will of the committee.
I'll defer to the chair. I'll motion to take item 2 and 3 up as a package.
Second.
Any discussion? All in favor?
Aye.
Aye. Would you come join us, please? We're joined by our city clerk, Brenna Leary, and by our state representative, Pat Duffy. Thank you both for joining us tonight. Okay, just before we begin, I want to just briefly read this letter into the record. This is from our rep, Pat Duffy. I'm writing to update you in the City Council on an act establishing an appointed treasurer for the City of Holyoke. After the City Council's vote this past spring, I filed this home rule petition, which calls for an election on November 5th. Subsequent discussions with the Secretary of State's office and the City Clerk's office in response to this filing have raised the prospect of the many logistical and costly challenges inherent in holding a special election on the same date as a national and statewide election. Looking more closely at these challenges gave rise to conversations with the mayor and other department heads where it became clear that this will likely impact the city's timeline. Will impact the timeline for the city's plans to implement much needed financial systems, policies, and procedures. I share this information with you so you can make an informed decision as to your next best steps. Sincerely yours, Pat Duffy. And then we also received, that was from July 31st. We also received a second letter, July 31st, from our clerk, Brenna Murphy Leary, who also wanted to weigh in and ask that we consider a different way of doing this as an alternative, potentially a special election, which would be held, based on this letter, at great expense to the city. She also wrote, if this is the option the City Council would like to pursue, I would recommend having the election in late winter or early fall to give enough time for a candidate to run for the position if the ballot question was to fail. Considering the City Council is the legislative body elected by the city voters, it would also not be unreasonable to have the City Council request a special act without direct voter approval. Therefore, I'm requesting that the City Council reconsider its June 4th, 2024 order. I would love to suspend the rules to allow our guests to be able to speak.
So moved.
Second.
Thank you. All in favor?
Aye.
Aye.
Aye. Would you like to just give us your brief and brilliant for your thinking and what you see as our next potential steps? Sure. So, just make sure you've clicked the on button so you see the green light.
I'm on. So first of all, thank you all so much for inviting me. I'm really happy to be here. Officially, it's just to, reiterate the letter that I sent, which recaps like a lot of discussions that happened since the home rule petition was filed. I also wanted to let you know that Senator Vilas and we had filed the legislation, so it was moving along. So Senator Vilas and I have put a little quash on it. Of course, actually at this point, it would be literally logistically impossible to hold an election on November 5th. So that's sort of the update as to where that stuff is at. But I wanted to be here because I know you're having conversations about next steps, and so to answer any questions that could come up from me. Pretty much any next step you took, if you were going to make this government change, whichever road you went down is going to involve a home rule petition. So I'm here to answer questions about logistics and timing on that.
Thank you. Do you want to speak as well?
Yeah, I agree with Rep. Duffy. Submitted my letter after having some conversations with Michelle Taznari, who's their legal for the Secretary of State's office. And she had expressed some of her concerns about doing a special election the same day as the presidential, and I had put those in the letter, and I had sent an email to the city council. I've been in conversation with Rep. Duffy as well, and I know the council's ultimately gets to make the final decision, and obviously I'll do what the council wants, but in my letter there was a little error because it did say late fall, I think, but I think what I meant was late winter, early spring. And then, like I had said in the letter, if the question was to fail, it still gives a candidate time to come forward and be on the ballot next November.
Okay. Any discussion from the committee at this point? We have some options that we need to discuss.
Yes.
We have options around a special election. We have options around instead doing this through a separate legislative mechanism. So I would love to hear where the committee is at this point, given we're in a different place than we were. Who would like to start? Yeah.
If we could also put into the record, sorry about that, I forgot to turn that off, to enter into our record the communication from Michelle that was with our clerk's communication. Hers was dated June 7th. And the clarification that I need relative to this, and I'm not sure who would answer it, is that she's questioning the authority of the city to hold a special election, period. But we were told we had to have, because our charter and the treasurer's position and the clerk's position are special acts. We have been told that in order to amend the special act, we have to do the home rule petition, and then the home rule petition has to go to the voters because that's how it was implemented in the first place. So it seems to me that if we push it forward, we're only delaying what we've been trying to do now for a couple of years. I understand the logistical challenges of the two sets of papers and all, but it seems like this will just delay it further because we'll still have to do a home rule petition no matter what we do.
Yeah, so
You know, so I don't see what we're gaining.
Okay.
So I'm just concerned that on the one hand, we're being told, so effectively, the home rule petition failed because it wasn't presented and the state legislature did not vote on it?
No, it actually, we just sort of, every piece of legislation sort of has a little road that it goes down, much as happens here. And so it's going down its little road, but Senator Vilas and I sort of stopped it from taking its next step, which actually would have been going to the Senate floor, because it was my, I was in meetings and had discussions and was told that there was a reconsideration happening about enacting the legislation and having the special election on November 5th.
I appreciate you sharing that, and I just want to be on the record that we did receive the communications, but there was no action taken by the city council changing its vote that occurred in very early June. So it seemed that there was, just my opinion, adequate time to do this, and it sort of seems like a decision was made, and now we can't do it, if I'm understanding you correctly. So
I'll just comment, and you may have comment on the timing too.
but I'm understanding we can't get it on the ballot for November 5th as of today. Is that correct?
There were a couple of different issues. One of them was that the home rule petition described the election that would be happening as a general election, and that it was actually it was a special election, and that's kind of the road that we stopped. You would have had to take another vote to say that, no, you really meant that it was a special election. And that's when conversations began to arise about.
But we never did get that. message.
Before we proceed,
Just
I
for
just
the
want
record.
to, acquiesce to what Councilor Bacon suggested, which is reading a section of this into the record, just so it's there. So this was another communication that we received June 7th. So it's from Michelle Tassinari from the Secretary of State's office, and she had written, I think the first question is under what authority can the city hold a special election for that question? Unless you have a charter provision or special act that allows it, it doesn't appear it's allowable under the general laws. In any event, holding dual elections raises some issues. You'll need to print separate ballots for the municipal election, and voters who vote in person, either during early voting or on election day, will need to check in twice, once for each election. Also, there may be certain voters who are only eligible to vote in the state election. If a voter moved within MA in the previous 6 months but failed to re-register, they'd be eligible to vote in the state election but not the local election. For vote by mail, you would need to send a local election ballot to any voter who selected all elections this year or just the November election. However, this means you need to go back through your applications to enter them into VRIS for the local election as well. You could mail the ballots out in the same envelope, but will need to provide clear instructions for returning the ballots. The voter will need to insert the ballots into separate inner affidavit envelopes, which you'll need to label to distinguish the state from the local. They can use the same return envelope, but if the inner affidavit envelopes have 2 ballots in 1 envelope, you would have to reject both ballots. The issue you'll have is that I'm pretty sure the state election ballot will already be at least 2 cards to accommodate the ballot questions in English and Spanish. Also, you'd likely need to print your local election ballot on the same size paper as the state election ballot in order for the tabulator to read it. Another point of confusion may be the ballot return deadline. For the municipal election ballot, all ballots will need to be received by the close of polls to be counted. For the state election, ballots postmarked on or before election day and received within 3 days are eligible to be counted. Just lots of moving pieces and administrative challenges to having a dual election. Michelle. Did you want to speak, Councilor Ron?
I did. I had a point. I was just going to add that I was looking back at my calendar before this to try and figure out the timeline, because it kind of did. We voted on it at the June 4th meeting.
I think so, yeah.
And then we had, there was, the communication was June 7th from the Secretary of State's office. And once we got that communication, the mayor and I were like, we should probably pull together a meeting. So that was when we met with, it was the clerk, Rep. Duffy, myself, the mayor, the law department, obviously the treasurer, since this would impact his office. And that was, at the time, we were trying to figure out if there was still a way to do this. And excuse me, that meeting was sort of, we ended up having a meeting as a group later in June. That meeting happened later in June to figure out what our options were. And so you might notice, after we had that meeting was when I filed agenda item 4 on here. Simply to lay out, I wanted us to be able to have all of the options laid before us. So I just wanted to give a little background on how the timeline of those things came to be. It was pretty much over the course of 2 weeks that we started trying to figure out if this is even possible. And that's when Rep. Duffy said, well, we also need you guys to vote on different language. And that was after our last meeting in June. So I just wanted to provide that timeline.
Yep,
From my perspective, I think the timeline was also complicated by the summer recess.
Yeah.
So the fact of the matter is, this, order that you put in August 6th, this was our first Charter and Rules meeting. We can't move something to subcommittee until we have a council meeting. Mm-hmm. And so we had to have a council meeting so we could move it to committee so that this committee could then meet on this topic to consider these materials that have come to us really since summer recess began.
If I may,
Yes, and then I think Councilor Jordan's hands as well.
I'll wait.
Okay, so the good news is I think we all want the same thing.
Yeah.
which is that we want to have the public have an opportunity to vote on this at some point, and that will make it for an appointed treasurer. And the question is, if we don't do it in November, what's the plan B? What are you recommending? What language do we need to get here? And when would we have the election?
So if we were to have a special election in late winter, early spring, we would need the legislation to specify that it's a special election and what the date of the special election would be. And it would have to be voted on by the legislature at least 35 days prior to the election date.
Okay.
One more thing, just, I know that's the date that's in the law. However, with everything going on now with early voting and mail-in voting, we want to obviously give time for the voters to be able to request ballots through the mail as well. So if it could be a little bit before 35 days prior, it obviously gives us a little bit more room to get ballots out in the mail as well.
Well, how about we take it one step further? How about you draft up whatever you recommend and need, and we just pass it at the next council meeting as a late file, and I think we voted unanimously in favor of all doing this, and we shot for the November election, apparently.
Yeah, I could definitely have the law department draft it up.
Yeah, I mean,
Question in the,
because there's apparently some tweaks you need, and that's the end of it, right?
I just want to add one more timing thing, which is not a problem, but just something that we all need to take into consideration. We have a 2-year legislative session, and our legislative session ends the day before the first Wednesday of the year, which this year happens to be Tuesday, December 31st. So depending on when it's in my hands, I'll probably consult with you all about, am I going to try and push this through now, or am I going to wait until January? I'll consult with you and the Secretary of State's office.
I have a follow-up question. So when it ends, oh shoot, sorry. Okay, I'm Italian, I talk with my hands. When it ends on the 31st, if, let's say, it didn't get through or whatever by the
there could
31st,
there could
you
be
just
unforeseen.
file it again for...
I can just file it again, and you all would not have to vote again, because it's either, I'm sorry to say, it's either one of the legislature's rules, or it's in the Constitution somewhere, but I did double check this. Your vote that you send me is good for 2 subsequent sessions. So even if I had to, if something, unforeseen circumstances, I couldn't get it through this fall, you would not have to take a second vote. I would just refile it on January 1st or whenever they let me refile it. But we would want to be cognizant of that timing. Yeah, so I would definitely be talking with you.
My question is around, I guess I have 2 questions. One is just logistically, would we need to effectively start again with a new home rule petition, or can we just have modifications to our current home rule petition and effectively submit an amendment so that it's already in play and we're just submitting an amendment as it continues on its path, or do we have to start from scratch?
I would defer to the law department on that. I'll advocate for whatever you hand me.
Solicitor Bissonnette, would you be able to weigh in on that question if you're able to?
Sure.
Thank you.
So it's up to the council to determine whether it wants a new petition filed looking to a spring date, or if it wants to amend the current filed order. My personal preference is that we amend. That way it keeps us going, lessens the chance that we lose it at the end of the year, and be mindful of nomination papers becoming available. I think, Brenna, help me with this, is it February?
we usually do them in January.
January, so.
January, yep. But they
would
have until
mean-
August, so there's definitely a huge window for nomination papers.
I'm wondering, just because of the treasurer
I haven't picked it yet.
papers, it still would be an elected office. If there's a way to move that date, having it maybe papers available in March and still having 5 months to signatures.
Yeah, there's nothing in the charter that says they have to be available by a certain date. We've just done January because that's what they've done for, I don't know, heaven probably knows. So we've done that. We've actually tried moving it up and we got, yeah, a little
the
pushback. So,
traditionalists, yeah.
and it's fine. It doesn't make a difference to our office one way or the other when we do them. So I would be totally fine with pushing it into March, right after a special election.
So my next question is around finances. What is the cost, just to put it on the record, of the special election, and do we have the funding for it?
So there is a transfer that is in finance right now for $30,000 from, I believe, the CAFO line item to special elections. And that was solely based on our conversations with the clerk.
Okay.
That would be what is needed.
I remember that figure.
Yeah. So that's why that's in finance right now.
Do we have any other questions for our guests?
I just have a.
I have my
comment.
hand raised.
So
Oh, I'm so sorry, Councilor Devine.
It
I'll call on
seems
you
that
right after
we
Councilor
would
Bacon
want to
finishes
move on
speaking.
it quickly. And it seems like the only amendment we need is to amend general to special. And otherwise, we're good
And
to
to
go.
name the date.
And the date.
Date, yep.
So it seems like there is a certain urgency relative to the election coming up that we would want to move it ASAP, right?
Honestly, I'm not really too worried. It's not controversial, you know, it's a home rule petition.
But just so we stay in your timeline to get it done before the end of the year, this year.
I mean, that would probably be better, but again, I think doing it as carefully as possible, you know, I don't think there's any reason to rush. You know, you guys are meeting regularly again, you know.
But it is pretty straightforward. We're just changing to special, and then maybe the clerk, maybe Brenna, you could give us a date that would work for you? Because I think the council would be wanting to work with a date that works for your office, right?
Yeah.
So,
Okay. Do you have a last comment, Rep. Duffy? And then I want to make sure that Councilor Devine can speak
Oh,
as well.
yeah, I'm sorry. Counselor Devine, is it all right if I make one more comment?
Oh, please, go right ahead. No problem.
Thank you very much. Let's be 100% sure that an amendment is the right way to go, as opposed to an.
Would you like us to clarify it with the Secretary of State's office? Is that the
it would-
concept there?
It would be more. I don't want to say who. Let's just be sure that's the best way to go.
Okay.
It seems a little messy.
Okay.
I'm not a lawyer, so I defer to the lawyers.
well, yeah.
Okay. I
Well,
appreciate
and
that.
Attorney Bissonette advised us.
All right, Councilor Devine, I'm so sorry I didn't see your hand up there.
No problem. Thank you,
Thank you
Madam
for joining
Chairman. The thing I want to talk about the most is if this is confusing to people like us, the last thing we want to do is confuse the voter. We want to make sure that this is as easy as possible. I have some questions about, I think what you're talking about is to put something, as Brenna suggested and as the Secretary of State's office suggested, that we don't do it in November, we do it either early or late April or late winter, early spring. And that's obviously my preference, but for those of you, like before I became a city councilor, I helped Brenna in elections, and it's not that easy as you may think. And if you're talking about having different ballots and different envelopes, trust me when I tell you, that will really, really confuse the voter, and you don't want to do that. So the other question I have, because it keeps going back and forth, and I'm even getting confused, what you're looking to do is put a question on the ballot to have the choice of being an appointed treasurer or an elected treasurer? Or would the city council just make it appointed?
The home rule petition, as it stands now, asks for the voters to approve our recommendation that the treasurer position no longer be elected, but instead be appointed by the city council.
Okay, and the other question I have
understanding.
is, where does this leave the tax collector? Because we've certainly talked about combining those offices.
That that would be a next step after we resolve the initial question of the treasurer.
Okay, and would that take place through the city council, that combination?
We'd have to make some sort of decision.
Yes.
My understanding, yes.
Yeah.
Okay, so then what you want, other questions that I'm thinking of is what happens to, first of all, the tax collector, and what happens to the employees that are employed in the tax collector's office? Are they part of a collective bargaining agreement? Are they going to get laid off? I think these are questions that need to be answered before, and maybe I'm going a little bit further than we need to do right now. But in the future, when we're deciding to combine those two offices, there's a lot more questions, I think, that need to be answered, particularly what happens to the employees that are working there. So I think that's all the questions I have for now. Thank you so much.
Thank you. And thank you for thinking also of the wider picture and thinking also of the employees in those offices. I know that, as we're sort of embarking on this, process, and it is not quick. It's a slow process. We're attempting to figure out different financial restructurings of city government. This is the first step, but there are many steps after that. And in fact, there are several orders in the jacket and charter and rules around looking at combined positions, at looking at who, answers to whom and who is structured where. I think those are going to be the next layer of conversations we have. And I also don't think that we can just assume that this is a special election moving towards. I don't think we can assume what we think the outcome will be. I think we're giving it to the voters to make that decision. We have to see what they decide, and then we will have to respond to that, whatever they decide. Yes, Councilor Jordan.
Just for a point of historical perspective to make us all feel a little better, it took the city 40 years to decide that we were going to have the system that we have today, which is from 1896 to 1936, right? So we're not taking too long.
Love
all
that
right?
optimism. That's good.
It took
least
them
it isn't
40
40
years to
years.
figure out the
All about
current system
perspective.
and they had to go back to the drawing board a couple times and get the voters involved. So you're all doing just great. So no worries there.
All right. Well, I think we've hit the point. We've discussed this. I think it might make sense at this point, given we're just on items 2 and 3 technically right now, for us to receive these letters and the communication from the clerk and from Representative Duffy, and move on to what action we want to take by taking up 4 and 5 as a package.
I'll make a motion that we receive the 3 communications
So
Thank you.
moved.
and the explanations that came with them.
Thank you. Any discussion? All in favor?
Aye.
I'd like a motion to take items 4 and 5 as a package.
So moved.
Second.
Any discussion? Okay, all in favor?
Aye.
All right, so item 4, this was the one we've referred to before from August 6th. Murphy Ramboletti ordered the city council reconsider its June 4th, 2024 order approving the ballot question regarding the position of the treasurer. Considering the opinion of the city clerk, which was made pursuant to information received from the Secretary of the Commonwealth's office, the charter change should be done via special legislation, as approved by the city council and mayor, as opposed to the city voters. And item 5, this goes back to April 2nd, McGrath Smith ordered that the city council adopt the provisions of MGL Chapter 43C for the purpose of changing the position of treasurer from elected to appointed. The reason why I want to take these two as a package is because effectively the April order is referring to the statute that we would use in order to actually move forward using special legislation. And I think early on there were a number of just to put it in perspective, there were a number of orders that came forward in front of Charter and Rules all around how we wanted to structure this question. Did we want to take it as an election? Did we want to take it through this other legislative process where we could, in fact, decide ourselves without giving it to the voters? And so I think items 4 and 5 are both that route. The conversation we're having is different. So I think in order for us to move forward with a special election, given what we have here, we would have to have a motion to substitute a line in item 4, or we could in fact basically suggest to the council that the suggestions in items 4 and 5 be rejected, and instead we want to substitute with a motion for us to replace it with language that says the charter change should be done via special election with a date to be determined in the month of, now January is what I'm hearing, by the city clerk.
Can I just comment, just because as the maker of the order, I just want to give a little, I gave a little background before, I think folks might have thought that I was trying to pull a fast one on everyone with this, but I really wasn't. I personally, I know that folks feel very strongly about putting this before the voters, and I'm okay with that. My motivation for filing this was also just sort of understanding that there is a time frame in which we want to have this special election. And when we were having the conversation in the mayor's office, it was like, oh, are we going to have to wait until, next fall? And I was like, I'd rather have us do what we are allowed to do. I mean, at the end of the day, we are allowed to do this. I'm not trying to do anything that we're not allowed to do. For me, it was more of a, sort of a last ditch effort in order to make sure that we get something to happen. But I mean, I respect the opinion of the voters. I'll also say, I know that there are a lot of people who are registered voters that also don't even realize what the treasurer does or what the treasurer, that it is elected. So, I wanted to just provide some background on why I felt like this should be laid on the table as one of our options, because I do recognize that we have been discussing this for a while, and if we weren't able to have a special election, that would just delay everything so much more, and that was not what I wanted to have happen. In an ideal world, I would love to just have us move things forward quicker, but I also respect the opinions of the voters, and I know that there's a lot of folks on the council that want it to be done this way, so I'm not gonna put up a fight or anything. I just wanted it to be in front of us, so that's all.
Councillor Bacon and then Councillor Jordan.
So I appreciate your explanation. And I also want to be sure that when we're considering this order, I don't think this was read into the record, but our clerk, Brenna Leary, did clarify that she would recommend having the election in late winter or early spring. So I think that recommendation is the one that I would want to consider under item 4, rather than doing it without the voters' approval, because her recommendation said that. So I would just like to make sure what she recommended is what we're talking about, okay? And as a technical matter, I would just note that under item 4, the city council can't reconsider its June 4th vote, okay? We could only have done that on June 4th. So I think in fairness to the information that Rep. Duffy gave to us, on August 6th, we could have amended the language to clean it up and said special election, if we had known it, but we didn't know it. So I think to remain consistent with the vote of the council and the recommendation of our city clerk, the motion I would offer is that this committee recommends to council that we either amend the petition to say special election on the date that you figure out, but I would ask for it to be sooner rather than later. And if a new petition is needed, that we approve them simultaneously so that we don't have to come back yet again, right? So we can vote to amend for the late winter, early spring. We can also vote, if needed, to approve a new petition to ensure that it moves forward to the voters. Because I think we're all in agreement that the voters need to vote on it. So that would be my motion.
I do want to name just into the record, just for devil's advocate, that the clerk did also say, considering that the city council is the legislative body elected by the city voters, it would not be unreasonable to have the city council request a special act without direct voter approval.
Right.
Which is this other secondary
Right.
piece.
But can you read the part where she actually made the recommendation into the record?
Yeah, I read both.
Okay.
Yeah, no, I think the clerk was attempting to present us a very balanced, here are two options. I would like you to reconsider one of these two.
Right, but she recommended one and said that we could consider another. And I just wanted that to be clear.
No, absolutely fine.
Thank you.
What I also wanted to name is that you can see my thinking in what I've written on the screen there. It's more that I'm thinking how we can do what we want with what we have in front of us. We don't have a motion that says, let's make a special election.
No, we have a vote
Right.
that says, let's make a special election of the council.
Where? I mean, item,
That hasn't gone away.
Right, but it did say, didn't it clarify dates?
Yeah, I think it said for the November election.
Yeah.
Right, but the vote to put it to the voters has not gone away.
True, but what
Timing has, because it didn't make it through the path.
well, right, but I would just say, like, to both of your points, we can't reconsider what we already voted on. So I would just assume that we have to do it again for January, this language
And
that
that's
says.
the motion I,
Yeah.
to amend it,
Okay.
to make it timely.
can we do that based on item 4 and item 5? Or do we need to have a new item brought to this body where we can do that? Is my question. Attorney Bissonnette, would you mind weighing in on that? My thinking was that we would substitute the phrase in order to allow us to do so.
You could take that course as well, but I think, I'm just checking it now. I think the rule is that regardless of which side you vote on a motion to reconsider, only at the initial meeting may all members vote on the motion or offer the motion. But I don't think there's anything in the rules, Counselor Bacon, that says you can't reconsider at a future meeting. And it clearly is allowable in the Roberts rules, and I don't see anything here to contradict it. So I'm going to continue to look, but I just wanted to make that point because the simplest parliamentary move would be to vote to reconsider, get that original home rule petition back in front of you. Then you can amend it or you can substitute a new one and then vote that out. I mean, conceivably, if we were up against a time, that could happen on Wednesday. But certainly it can happen in 2 weeks.
If I may. I'm not going to pretend to be an expert on Robert's rules, but I will say that I looked up the motion to reconsider. And in Robert's rules, it says it has to be done in the same meeting as the vote is initially taken. It's not to say that we can't amend what we voted on at a future meeting. It just needs to be in a different form. But to Attorney Bissonnette's point, he feels we're in order to pass the motion I made and bring it back to council to amend that vote. Without starting over. I mean, a reconsideration would make us start over which I don't believe would be in order. But I think we can move the motion, which I think achieves what you were doing with that language that was up on the screen, if I read it quickly, right? Accurately.
Do you want to read? Sorry, yes, Councilor Jordan, and then Councilor Devine.
Couple of things, and I'll help hopefully with a little background here too. By the way, this issue has come up before the council and has been vetted previously. I would point the law department to there was a legal opinion in 2015
And then
when
she
we
may
did.
call him.
Patty, you're not on mute.
Oh, am I?
No, you're
It's Patty.
just Patty.
Okay.
Oh, Patty's not on mute, okay. So in the 2015 opinion, you couldn't reconsider. You have to do a rescind.
Right.
That was the ultimate determination of the law department at that
Just trying
time.
to listen to what Jordan-
Having said that, I like where you're going with this, Counselor McGrath-Smith. I think you're onto it. I think what you would do is amend item 4 as you've proposed, and Counselor Bacon agrees, and do it to just as they suggested. And then we would amend it with the language that they're going to give us. Hopefully, maybe if you have it for Wednesday, great. If not, we'll do it in 2 weeks. But whatever the case may be, I think that is the best approach. We just amend 4, and then 5 we wouldn't need anymore. We would just consider that complied with.
Yep.
And then we all live happily ever after. And that's the end of it.
I think we're all saying kind of the same
Yeah.
thing. Maybe a
And
little
oh, by the
different
way, just for more historical context too, when this rule went in and the legislature adopted it in June of 1936, that they sent it to the voters for a vote. And it was approved by the voters of Holyoke in November of 1936. So that's one more reason of the many reasons the voters should vote it, because this identical rule that we're seeking to turn was approved by the legislature subject to the approval of the voters, and the voters approved it. So if you're going to take it away from the voters, I think what we're doing is the right way. So, although I did look in the law, it doesn't appear the legislature has to ask. It's up to you. Have the power not to ask the voters. That's your decision. Apparently, the long historical context is that you always do, and for obvious reasons, right? Because you're revoking a prior vote of the people, So, but anyways, that's your power, not ours. So, but thank you.
All right.
So
Council-
since my motion wasn't seconded.
Oh, I'm
would it
sorry.
do whatever
I will.
you guys
I
want?
can second it.
Just 1 second. Councilor Devine?
Yeah, if somebody can just explain that motion again, so I know, and I'm assuming that if your committee passes it, it'll go on to the regular city council meeting?
Yes.
Coming up on Wednesday?
Yes, it's on the agenda.
All right, and if you could just repeat it again, I'd appreciate
Yes.
it.
So the original motion said, order that the city council reconsider its June 4th, 2024 order approving the ballot question regarding the position of the treasurer, considering the opinion of the clerk, which was made pursuant to information received from the Secretary of the Commonwealth's office. The charter change should be done via special election as approved by the council and mayor, as opposed to city voters. The motion is to substitute from that phrase, starting from the charter change to the end of that sentence, and to replace with the following. The charter change should be done via special election with a date to be determined in the month of January by the city clerk.
Second. That was Counselor Bacon's motion. Or she said it, but I didn't realize that she was
Thank you
saying
very
it, so
much.
I'm going to second it.
Thank you.
Okay, any further discussion? Okay, all in favor?
Aye.
Aye. Can I have a motion on item 5, that it be complied with, or that we give it leave to withdraw? Either is fine.
I would make a motion that it's complied with.
Second.
All in favor?
Aye.
Aye. Okay. Thank you so much for coming in. I really appreciate you too.
Thank you.
Keep us posted.
And thank you to all the counselors who came and joined and weighed in. Appreciate you as well.
Okay. All right.
Yes.
Take care. Have a good night.
Okay. I believe we're going to table item 6 on the basis that we have not yet received language, nor have I drafted language for us to look at that's specific.
I'll make a
Motion to table.
Second.
Waiting, pending legal draft.
Second.
It's something that we don't require legal draft because it's a rule in city council, but we do need to have a draft that we can look at. I do have drafts of others that we can look at, because otherwise it's sort of what happens here, right? This has been tabled 1, 2, 3, 4, 5, 6 times because you talk and there's lots of points, but then you need a draft at some point to look at. So I will draft it before the next meeting.
In fairness to
gonna
you
say,
though,
could
I'm happy to
Jeffrey
help
give
you
us-
with that
Yeah,
because it's
I would love
like,
that.
you shouldn't have to do all the legwork.
Yeah.
I would love to do that.
So I'll work with you on that.
Yeah,
Thank
and
you.
Jeffrey
I
could give
appreciate
us a
that.
couple of examples to look at too.
Well, that's true. Yeah, we can ask like what other local councils have something similar. But yes, you and I,
Yeah.
we can meet and we can come up with a draft.
We'll figure it out.
I just think for my own brain, maybe not for everyone's, I need something in writing
I like
Yeah,
to
agreed.
know what are we saying here? What are we agreeing to?
So we're not waiting for legal, so we
No.
won't have that.
Okay, so I'm just going to read into the record. Murphy, Ramboletti, and Jourdain order that the City Council adopt a rule to establish a 2-year legislative term where any orders pending in committee or not acted on by the end of the legislative term must be refiled at the start of the subsequent legislative term. We have a motion to table with a second. Any discussion? All in favor?
Aye.
Okay, item 7. This is from McGee.
Motion to take up item 7.
Second.
All in favor?
Aye.
Ordered that City Council Rule 9H be amended and reworded in order to make the process of changing or updating an ordinance a smoother process. This has been tabled 3 times. We have some draft language to look at. This came of myself also meeting with the city solicitor's office. I met with Ms. Manteleschi, Bissonette, and Lisa Ball. We looked at the original 9H, and then we considered some possible points, and I took it home and I drafted it out. I will say that I'm in education. One of the main things that you want to go for is something that is plain spoken enough that everyone will understand what it means, and it doesn't leave a lot of room to have so many different interpretations that then you get confused about what the rules are. I'm just going to read the revised 9H.
Can we ask Jeffrey for hard copy of that?
Jeffrey, do we have hard copies of this by chance?
We got it real late on an email.
No, I hadn't had a chance to print out hard copies of this. I can try to do that right now for you.
Thank you so much. That would be great. Okay. So the goal here was to reword it in order to make the process of changing or updating an ordinance a smoother process. So here's what it is right now. The ordinance committee, as a revised draft, the ordinance committee shall submit any proposed adoption, amendment, or repeal of an ordinance to the city solicitor for review and approval as to form and legal character. The city solicitor will then prepare a legal draft for presentation to the ordinance committee. This draft must be provided to the ordinance committee at least 48 hours prior to a scheduled subcommittee meeting where the ordinance is on the agenda. If the ordinance committee does not approve the draft, they shall submit any requested changes in writing to the city solicitor to facilitate revision. The revised draft must be completed and presented within 2 regularly scheduled subcommittee meetings. Revised draft must be provided to the ordinance committee at least 48 hours prior to the scheduled subcommittee meeting where the ordinance is on the agenda. Once approved by the ordinance committee, the draft shall be submitted to the city council assistant. Jeffrey's point, along with Brenda, was that this should be changed to the clerk, who will distribute it to the city council at least 48 hours before the scheduled city council meeting where the ordinance is on the agenda. This is a draft. I would love us to tear into it a little bit around what is good here, what we would want to see taken back and revised for another draft to bring back to the next meeting. What do we think about this draft? What's working? What's not working? Yes, Linda, we can.
Thank you. So one of the key points for me is that the order was simply to clean up the language and make it smooth and more easily understood. I didn't see anywhere in the order that we should change the intent of the rule. So my first concern is that in the current rule, it allows for both majority and minority legal drafts to be created out of the ordinance committee. And whatever we do with cleaning up the language of the rule, I don't want to see the minority rights taken away.
Can I ask a question about that? So I'm on ordinance. I have yet to see a minority opinion. So it may just be that when I was looking at this draft, I would love to hear, like, where has the minority opinion been really important in the past? How often is it used? What's the mechanism, right, in that? And is it just important to name that a minority opinion can be shared? And is it in writing? Is it shared out loud as an amendment to the committee report? So how do we name that here so it's clear? I'm not against it in any way. It's just that I've never seen it used. And so I would love to hear more about that.
So what has happened in the past is if an ordinance is voted on and it's 3-2 in the committee, it's generally been said that the motion fails. But this rule allows for the minority to seek a legal form that then can be reviewed by the council, which if we take it out, would not allow for it. Now, just because nobody has chosen to request that, I would not want to give it away. Because what's been happening over the last few years is we've been getting legal drafts for ordinance changes before the committee's even taking it up in committee. And I think it's critical that the order of things is correct. And I hope we're not even going to talk about 9J because it's not on our agenda and there's no order before us. We shouldn't even have that language on any forms that are in front of us because it's an open meeting law violation. So I think it's very important to me that the order of things is correct, that the council as the elected representatives of the people are requesting the law department to put something in a certain form. And certainly we respect the law department's review where it may come back to us and say, well, this isn't really in order in our opinion, which then the council considers the opinion of the law department and then may or may not follow it. Because, as we've seen, one year we get one opinion and then another year we might get the opposite opinion. But nonetheless, I think that's an important part of the process. But I just don't want to see any minority rights given away in cleaning up the language.
So what you want to make sure that it includes is when there is a 2-3 split vote on the ordinance committee that
No, just the language that it says in the current rule.
Do you want to read that part?
Let's see.
That you want to make sure is there. I just want to two pieces just to say why you have in front of you what you have in front of you. One is because it says amended. It didn't just say reworded. Amended means changed, and so that's why I was looking at that, whether that's the interpretation of that was wished in the original order or not, and the reason why.
It listed the purpose.
Yeah, so again, but this was my interpretation of what a smoother process would be, because there seemed to be some real conflict between what the council wanted the process to be. From my own perspective, what I've heard many times is a lot of conflict around wanting legal forms, legal thinking that it should be. It's technically here, we draft it. That hasn't been happening. So if we're going to make it smoother, one of the pieces we have to name is who do we think is supposed to be drafting it? Because in our rules, they're not supposed to be putting it in legal form before we've drafted it. And that hasn't been happening. People have been talking, and then they want the city solicitor to take the conversation and turn it into legal form. And I think that has created just enough space for us to have real issues. So I think in trying to create a process that is smoother, we need clarity on who is drafting it. And the reason why I added in this concept that it's written, the written piece could be from the city, it could be from our assistant, but that it can't just be from a conversation they have to watch in a video. They have to distill our wants and needs. That even if we're naming a few, here are 3 bullet points we want in this legal form that you give to us, trying to just create space for clarity, so that we're passing communication back and forth in a way that we all know what we want and what the order is. The reason why 9J is on here is because immediately when I started to work on 9H, you don't need 9J anymore, because everything that 9J does is already in 9H. right now it's odd that you have 9J that further explains the process that's supposed to be described in 9H.
There's some things going on in 9J when it's
Okay.
my
We
turn.
can't go there.
When it's my turn.
But I know, but we can't take up 9J because we don't have it before us.
Well, we can't amend
Properly.
9J tonight because
Pardon?
you don't have
No.
9J on the agenda, but we can.
But I think as part
well,
of
you
just the
can discuss.
conversation,
Yeah, just
I
a
think it's
conversation,
important to
yeah.
talk about this in
Yeah.
the context of other rules.
All right.
Because another order may be put in to change 9J next. And it does seem that the two are connected. Yes, Councilor Jordan.
Okay, a couple things. One is I don't have a lot of opposition to where you're going with this with a couple of points. Linda makes makes a number of good points, but one is in the first paragraph of the original 9H, it speaks to both the majority and the minority have a capacity and an ability to get their item drafted into legal form. Why that's important is the obvious. The council needs to be able to vote on things in legal form. So if 3 councilors vote for this format and then 2 vote for this, they're both in legal form, and then the council is open to vote on each of the 2 that they wish, okay? But if one of them, if the minority doesn't get its opportunity to have it in legal form, there is no alternative version for the council to vote on. Okay, so so the first paragraph of the original 9H, you need to maintain that character. And of course, that is indirectly speaking to a Robert's Rules of Order, which is that committees have the power, both majority and minority, to make a committee report. That's in Roberts. And 2, theoretically, when we're signing the jacket, 3 or more counselors has to sign the jacket, because that's in Robert's Rules of Order, that you must have a majority of a committee report. And by the way, these don't come up too often that there are minority reports, but on the bigger controversial issues, these do come up from time to time. And we've actually had people who didn't sign the jackets where we couldn't get 3 signatures because people said, you know what, changed my mind. And so it automatically goes back to committee. Okay. So that's kind of an important thing for you to remember. 9J, a lot of what you're doing is modernizing, and which I don't have a problem with. And you already are going to change city council assistant to city clerk.
Yes.
A lot of this already speaks to open meeting law, right? You can't give us stuff in documents if it's not here to us in 48 hours anyways.
Yep.
9J goes one step further on a couple points. One, to your point, ordinances shall not be drawn into legal form unless the ordinance committee has taken a vote on the matter. We've done that because we want these discussions to take place in ordinance. We might have flexibility on whether that is an absolutely needed, okay? But generally speaking, that's the way we've done it. And that was kind of where we went in the last year or so, which is we're going to have these preliminary discussions in the committees. And then once they kind of figure out, you know what, I think we need an ordinance change on this. Ordinance committee, do your thing. And we've laid the groundwork and have done the research. So now it goes to ordinance. They then draft something into legal form if the ordinance committee agrees that we should do something like that. The rest of these are important, but one of them, it looks like you've already grabbed, which is the legal form for ordinance. It shall be 48 hours prior to a council meeting. So you grab that in the 9H, so that could probably be stricken, so it doesn't need to be duplicated. But the next hook is an important one. The council 2.5 years ago made this last sentence, and the council did that wisely. Because legal forms are not coming in within 48 hours, we made it beyond just let's suspend the rules with 2/3. It was, no. We don't even have, theoretically, if you don't have it in 48 hours, open meeting law says party over, lights out right there. But this just sort of emphasized what the law is saying, which is any objection from anybody, then that's it. So I would like to have that this council discussed that and felt that was important. I think that was unanimously adopted, that last sentence. So I think sentence 1 should be kept, 2 you've already got, so that could be deleted, and sentence 3 we should keep. So that's kind of my take, but yeah, I mean, where you're going with it, to kind of redraft the middle paragraph, yeah, that's all well and good. So thank you.
I'm going to restate my objection to talking about Rule J until it's fine if we amend H and then it combines everything that's in J, but then we need to talk about that as a separate thing.
For sure.
And if it's redundant, okay, at that point. But right now, there are key things that aren't in H that are in J.
Yes.
But I
And
do really
appreciate the context.
But
That's great.
I really appreciate the part where this clarifies that the law department will prepare the legal draft on the part that you put together, because that, to your point, is very important.
I also think where it says ordinances shall not be drawn into legal form unless the ordinance committee has taken a vote on the matter. I've seen the opposite happen.
And that's
Where
wrong.
it's been conversation.
Yes,
And
and-
then they say, well, we can't vote on it yet because it's almost like we're expecting the legal form in the subcommittee instead of by council. So one of the things I was trying to make clear in 9H is like, where is that legal form existing? Because it seemed very confusing based on what we're actually doing compared to what's here.
But it does need to come back to committee before it goes to council.
And I think if we,
That's correct.
and I think we could all agree too, that I've even seen where people file orders and it's already coming in legal form. And it hadn't even gone to committee yet. So it's got to be going through the ordinance committee to have them say, put it in the legal form. And not just, because some of them, it seems like you wait a long time. I mean, the law department has a lot to do, no question. But I'm saying some of them, it takes quite a while to get the legal form. And others, it's like,
Yeah.
boom. So
Okay. Was there any other discussion? And this gives me enough to go back in and redraft it for next meeting.
Yeah, I'm good. Never mind. Yeah.
I'd like to make a motion to table for the chair to come back, if that's what you're
Yeah.
suggesting you
Yeah,
want to
that's what I'd
do
like.
with revised language.
I think you're going
as
in the right
discussed.
direction. I
Yeah.
think it's good.
Yeah.
Second.
Okay, all in favor?
Aye.
Aye. All right, let's move to item 8.
Motion to take up item 8.
Second.
All in favor?
Aye.
This is going far back. Now we're going back in time to December 20 of 2022. This was from Lisa Ball, city solicitor. Legal opinion regarding whether a city council seat is vacated if a ward councilor is elected in one ward and then moves to a different ward during their term of office.
I would make a motion to receive and that the order's been complied with.
Second.
Should I read it into the record as discussion, or do we want to just?
It was
move
already
forward?
received by the city council.
That's true. Yes,
So-
and there's some things in the jacket that I think, I don't know
it's-
why they're still here.
Right, I'm not sure. I think that was just sort of a leftover.
Okay, so then any discussion? All right, all in favor?
Aye.
Thank you. All right, next item 9. I think this is, we're going in the same direction
Motion to
here with
take
this
up
one.
Item 9.
Second.
All in favor?
Aye.
So this is from October 17th, 2023 from Councilor Puelo. This was a copy. The original went to public service. Ordered that the city solicitor, Lisa Ball, review section 2, 156 and 162 of the charter covering legal opinions and provide a written legal opinion explaining when is the department allowed to refuse to provide legal opinions. Not only is it a copy, sections 2, 156 and 162 refer to ordinance. They don't actually refer to charter for the piece that they're saying this order refers to.
And it was a copy, and we can't act on it anyway.
Yes.
So motion that it's complied with and say goodbye.
Second.
Okay. Any discussion? All right. All in favor?
Aye.
Item 10.
Motion to take up item 10.
Second.
All in favor?
Aye.
This was February 6th, 2024. Divine and Rivera, Israel Rivera, ordered under city council rules, please add the following. New rule every 2 years after being sworn in. The city council president shall set the seating arrangements of the city council. Consideration shall be taken for any legitimate handicap preference. Jeffrey, can you share this on the screen? Again, one of the pieces that I've been noticing is that sometimes things come in as a concept rather than here's the language. And that can mean that things just get stymied and stuck. Okay. And so I will defer, I think I see, yeah, Councilor Devine's hand up. I'll defer to the maker of the order to give us some context. And then I'm just going to share what the potential language change could be if we choose to move this to council. Councilor Devine.
Yeah, I'm just trying to read this first. Okay, the intent of this was to, and I don't see Israel Rivera here, but the intent of this was that because there was such a commotion about the seats being changed, that my opinion is that the city council president shall set the seating arrangements of the city council. Perhaps we should add by asking city councilors their preference. And then consideration shall be taken for legitimate handicap preference. It doesn't say that their preference is going to be taken, but at least they have that ability to check with the city president, council president, where they'd like to sit.
Thank you. And I just want to, I can't control the room, but I will say, I feel like we've talked about this a lot. I would love if we could keep comments to what at 7:37 p.m. feels reasonable, knowing that we'll probably likely talk about it in council, and that we've talked about it many times in council. I'm not trying to quash conversation, but if we could do it in a way that's concise or succinct. In the revised 1D, the original just says the seats of the city council shall be numbered and no member shall change their seat but by permission of the president. I will say some of the language, to me, it always seems anachronistic. Did they, at one point, were there actual numbers on desks, right, instead of names? And there, I mean, like, where did that even come from? Or did it just, like, theoretically mean your seat is this number, right? And no member shall change their seat. There's been different interpretations of this, and I've heard them. So I think I hear the order here is to clarify it, that they do mean that, in fact, the city council president sets seating arrangements, and that consideration shall be taken for a legitimate handicap preference. So that's where I just subbed in that language from the order underneath the original 1D if we were to vote on this and move it to council.
I have two suggestions.
Councilor Bacon.
So to that language, my suggestions would be to add, set the seating arrangements of the city council for the newly elected councilors, and keeping, so now I'm going to put it in the context. So we were all assigned our seat when we were new. That was the way it was done. That's the historic context. So then we were in that seat unless we requested, could we move for one reason or another, which was usually granted, but maybe not always. So I would like to keep that the president assigns the seat to the newly elected councilors, but if councilors preferred to keep the seat they originally had, they would be able to do that. And that would be the same as asking for their preference. Similar to, not the same as, but similar to. And that way I think you kind of have a win-win, but.
I hear it. Yeah, I understand that. And I think sometimes it's, sometimes these rules have so little specifics that precedent that takes this large shadow over all of it. I understand that one of the concepts here is who has power. Is it the role of the council members to be respected for seniority and to have control over their seats? That's a form of power. Or is it that the city council president has the capacity to say, no, I command the room? It really comes down to that. And I think in our system where we also elect our president, I would prefer them to be able to command the room. which is why I do support it as it currently stands. It is not without some understanding that it is a break from precedent, but I do think that the person that's running the meetings needs to be able to command the room. Councilor Murphy-Ability.
I like how Springfield does it, actually, now that I've really kind of looked into it. Do you guys know what they do?
No, how did they do it?
It's a draw.
It's random.
So they pull the numbers, or the names, and it's random.
Sounds fair.
It's random. And so it takes it away, it sort of leaves it up to the universe, if you will. And that's their seats for that term.
I could be convinced to support that.
So I'm just throwing it out there, because then it's like, it's nothing that we can fight over. It's just the luck of the draw, and that's who you're with.
And Madam Chair? Yeah. So I just want to comment that I appreciate Councilor Devine's offer of considering the preferences of current counselors, but I do think to just make it random then avoids the whole preference, favoritism debate and discussion that can happen. So I like it.
Am I hearing a motion to amend or substitute?
So
I'm
I
still
will offer,
Or are we still sitting with this? We want to think
I will
about it.
offer a motion.
You don't have to make a decision tonight.
Well,
Jordan's
it's
like, I don't know how.
That's till January of
How many
26.
times has this been tabled?
I think this is our first time bringing it up.
This is the first time.
Oh,
I wanted us to cool off before we talked about this
He has
one.
a hand up. He has a hand up, just letting you know.
If I could, Madam Chairman.
Yes, Councilor Devine.
Okay, I think that's a great idea as far as whatever other cities do. I'm certainly willing to give my order leave to withdraw, except I also have Councilor Rivera on this order. So, but I definitely like the what Tessa had mentioned about other cities doing it, the luck of the draw. The only problem, and it may not be a problem, one never knows, as far as the consideration to be taken for any legitimate handicap preference. But other than that, I think it's a great idea to just draw, and that's what you're with for 2 years. I think it's great.
Thank you. What would we want? I'm sensitive to, yes, there's a co-filer in the order who hasn't gotten a chance to weigh in. Would it make sense for us to table and just get new language and also see if the co-filer of the order is okay with that?
Sure,
okay with me,
yeah, that's fine.
with the maker. Okay, so I'll make a motion. Well, wait, first I want to make the motion that we add to the language that the seating would be determined by, a
random draw.
A random drawing.
Yeah. At the first, I think that I can look at what their rules say, but I think it said after swearing in, after voting for the president, then they do the random draw.
And then you just pick, like, the first name out gets to pick whichever chair they want.
No, the way they do it
First
is
name out is one.
they start at one end and then it's just they go in order. I can look at what
so
the
we may have
exact
to be
language is.
specific.
Yeah, we can, whatever works. I'm just, we can look into that. I'll definitely like copy and paste what they. And I watched after the whole thing, I was like, oh, wow, what do other cities do? So I watched their first meeting, and that was kind of how they did it, was just starting at one end to the other end. So,
Okay.
All right.
So
Well, there's a couple ways to consider.
sure.
Is I was thinking you'd almost like, you win a door prize at you go to a lottery.
Oh, you
thing.
get to pick.
So you get to pick, right? So your first name out, all the chairs are open. You don't get the president.
Power
right?
chaos.
Right? And then
your
you
name
pick, and then the next person picks, and you get to go wherever. I think that'd be actually even a little better because now you have
No.
a little bit of say as to where you're going, right? So if you
I could still see getting yelled at.
I could still see
no,
someone choosing
totally
to take
random.
someone's seat knowing they wanted that seat.
Oh, that's a good point.
well,
If there's any choice involved, this could go badly.
Well,
Random has got to be random in order to
well,
work.
it is random because your name, you could be the first one drawn, and you have no problem. I mean, I'm going to kind of speak just to get it off my conscience. Is not only if we're going to stay with this system, definitely handicap, right? We do have that, obviously the Howie situation, but in addition to that, I would say seniority. The president should take that into consideration too. Our system basically has been, your chair is your chair until you give it up. That has always been the tradition. That's why you heard so much pushback. I mean, that goes way, way back. But if you wanted to move, you needed the counselor, the president's permission, right? So he or she would pick. The new people fill in whatever's left. That's how it always worked. I mean, maybe we should have wrote that in the rule.
I was
better.
told where to sit by Todd, but
Oh, really?
yeah,
Oh, that's not very nice.
When I was new, I was told where to sit,
yeah.
Yeah.
but then that became my seat. So
Yeah.
I saw the president as assigning it to the new people.
Yeah.
How do we feel about coming up with some language for next meeting?
But that sounds good. We, like Kevin said, we have until
Got till January of 26 to
Yeah.
make up our mind
But
on
I
this.
really don't mind the random drawing.
I think it takes some of the
that's an
drama
elegant
out.
solution.
but
We have enough drama. We don't need
which we sure do. Yeah,
Drama.
that is one thing we can all agree on.
Yes. Okay.
All right.
So
Can
was
I
that
have
a motion to table?
Motion to table for revised language ties to a random seat selection process.
There you go.
Yeah, and we can discuss it more at the next meeting.
Yeah.
Yeah.
So moved.
Second.
Any more discussion? All in favor?
Aye.
Okay, item 11. Ooh, last one.
Motion to take up item 11.
Second.
Okay, all in favor? Aye. August 6, 2024, McGrath Smith ordered that Rule 4B be amended to reflect current practice and open meeting law, clarifying that items for city council meeting agendas are due at noon, not 1, and adding that a Monday holiday would also change the deadline to Thursday instead of Friday. You can see this up on the screen over here. You can see that the underlined text is what is different from the original. Does that look right?
Yeah.
So no order, request, resolution, or other form of business shall be presented to the city council except as provided below, unless a true copy of the same shall be filed in the office of city clerk on or before 12 o'clock in the afternoon of the last Friday before the regular meeting of the council, provided that if any Friday shall fall on a legal holiday, or in the case of the Monday prior to a council meeting is a holiday, such order, request, resolution, or other business shall be filed on the last Thursday before the regular meeting.
Yeah. If I may, the only
Yes.
thing that
Please.
like I was thinking of instances where this does happen, and there's been
Yeah.
a few times where the city clerk requests that we do it early, whether there's like
With the election.
election or if she doesn't have the staff capacity to do it, she's requested. So maybe just adding something.
Or on the request of the clerk.
Yeah. Yeah.
I mean, the main thing is the 48 hours.
Right.
That
Exactly.
we're complying with that, right? I mean, that's the concern,
Yeah.
right?
And I definitely don't think I even realized it said 1 o'clock in the afternoon.
Well, there's a lot of rules in here that, again, like people get so used to
We
the
always do it
precedent
like
of
12,
things
but
that
it's
maybe
just
what's on
been-
paper isn't even what's being done, but it feels like a rule.
Maybe or upon request of the clerk to comply with open meeting law.
But I like that, but also, does that get at Councilor Murphy-Ramboletti's point that sometimes it's just like a staff capacity issue?
You still have to comply, though, to his point.
Yeah.
Oh, so it's
wait.
like because they're attempting to comply, they're saying, can you get it to me earlier so that I can
They
comply?
can ask
You don't want to
us
leave it too
for more
loosey-goosey.
notice.
Somebody says, not Brenna, she wouldn't do this, but I'm saying.
No, but we're making it for the clerk, not for Brenna,
what if
right?
they-
The clerk could be,
You don't
who
want it
knows
to-
who the next clerk is, right?
Right. So you don't want to, what if the clerk, you can't leave it too loose because the next clerk is, I want it a week in advance.
Yeah, you can't do that.
Well, no, because it says only
No
the
later
last
than.
Thursday.
Does it say no later than?
So I was just saying, or upon the
Or
request of the
before.
clerk.
That's fine.
Because then it could be not just because there's a holiday, but because there's another reason
Yeah, I think it's fine.
why they need it early. They can, or upon the request of the clerk, they can request that it's Thursday.
Yeah. That way it's not
But they
saying a
can't, they
week
can't
before.
require it
Right.
because it's a matter of law, but they could request it.
Yeah.
Okay.
I think that works.
As long as you feel
And we
it's,
would usually
as long as
do
you
it.
feel it's tight, the language, and that's fine.
Well, is it?
Well,
Let's look at it again.
Let's see here, provided that if any
clerk
Friday
wouldn't
shall
be able
fall.
to say you can't file
Is
an
it the,
order.
or that the Monday prior is a holiday, or upon such order resolution shall be filed on the last Thursday. It's still gonna be the Thursday.
Right.
Okay.
Yes.
Right.
No matter what, it would be the Thursday is the earliest they can move it is one day.
So they can't push it earlier than Thursday.
Right.
But
Fine.
here's the
Then
thing.
that's fine.
No matter how
Yes,
tight
Counselor
you
Bacon.
make this, there's still the late files, so.
Which is apparently there
is
can
another
only be
rule.
10. I was in the rules looking like,
Well,
oh, that's interesting.
Except that we can suspend that too, so, you know.
Yeah.
And life goes on.
I like this. I'm good with this.
All right. Do I have a motion to accept the revisions as amended here?
So moved.
Or
Second. Jinx.
Yeah, that was someone needs to someone owes somebody a Coke there. Okay. So we had the motion, we had the second.
Yep.
Any further discussion?
No.
All in favor?
Aye.
And a motion to adjourn.
Motion to adjourn.
Second.
All in favor?
Aye.
Aye. Thank you,
Have a
everybody.
wonderful evening.
Thank you.
Thank you.